Okay, welcome everyone. This is the Information Society Law Center conference, the first conference. I am Pierluigi Perri, I'm the vice coordinator of this information center. Professor Giovanni Ziccardi, who is the coordinator, apologized, but there was an unexpected overlap with the dissertation today, so now the Professor Ziccardi is at the dissertation and will come as soon as possible. This is the first conference and will be entirely online, but is also broadcast on LinkedIn, Facebook, and YouTube. So we expect to have several attendances from all over the world. The idea behind this conference is to give to some scholars from all over the world, which are also fellows of our center, the opportunity to show the topic and the research activities that they are doing. For this reason, we asked all our fellows who want to participate in this conference to prepare and to present an extended abstract and to discuss this abstract during the conference. The conference is about 6 different topics. I'm just giving a brief list of this topic. The first is cybersecurity, which is this morning, and we will have 6 papers discussing some new frontiers on cybersecurity. After, in the evening, we have data governance, which is mainly about the processing of personal data and related legislation and so on. And tomorrow, because it is a 3-day conference, we will have in the morning cybercrimes with Professor Giovanni Ziccardi and 6 other scholars. And after, in the evening, the digital rights with Samantha Stanco and the scholars presenting some papers on smart cities, vulnerable subjects, and similar. And the last day, we have regulations, which is about mainly the new legal texts that are under discussion nowadays in Europe for the so-called digital strategy. And the closing of the conference is about legal tech, which is the use of technology for legal profession and for legal professionals. So as you can see, we will have 3 very intensive days, and I want to thank first all the fellows for presenting their very interesting extended abstract. The idea is to give the floor to every single fellow in order to present the extended abstract and present their research lines. And after, we can open to the discussion. We already received some questions from the other fellows who read the paper, the extended abstract presented. But of course, we are very happy to receive other questions during the conference. So you can interact with the chat or with there are other tools where how they can interact with us? Or in the comments. Okay, so we will check every possible place where you can send some question or where you ask for some clarification. So I think, and I don't want to borrow other time to the speakers, so I think it is better to start. And we start with Ludovica Sposini, who is presenting an extended abstract entitled Justice on Digital Platforms, Internal Complaint Handling System and Mediation in Platform-to-Business Relationship, a Call for Reform. Thanks, Ludovica. The floor is yours, and I will check the time.
Thank you for having me here. And I have some slides, so I think I can present it. Okay, so just a moment. Okay. 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 I think we are almost done. Okay. I think it takes a little bit of time, so I can just start without the slides. So, first of all, I'm Ludovica Sposini, PhD candidate in law at Scuola Superiore Sant'Anna. And okay, here we are. Perfect. So at the Scuola Superiore Sant'Anna in Pisa, and I would like to give you some preliminary elements about my paper, my extended abstract, actually. Okay. Can you see my slides? Can you confirm it? Because I
now yes.
See.
At some point they
okay.
disappear, but now we can see them. Thanks.
Okay, thank you. Because okay. So of course, when we talk about the P2B relationships, we talk about a symmetrical contractual relationship, and where we can find a lot of abuses of platforms and dependency position of the business users. My extended abstract aims to analyze the regulation 1150 of the 2019 of the European Parliament and of the Council in promoting fairness and transparency for business users of online intermediation services, which is the first piece of legislation, European legislation, which aims to regulate directly the position of the business users and of the consumer. In the objective and the scope of the paper is the analysis of the alternative resolution systems contained in the regulation, in particular the internal complaint handling system and the mediation. And the main research question is, are they enough and functional in ensuring the full rights of defense for business users against the abuses of digital platforms? So in the regulation, we can find at the Article 11 of paragraph 1, the fact that providers of online intermediation services should provide for an internal handling system to address the complaints of business users. So in the first part of the extended abstract, I focus on the internal complaint handling system. And from the Article 11, paragraph 2 of the regulation, we can find some characteristics that the internal complaint handling system must have. In particular, they must be freely accessible and free of charge for business users, and ensure to handle with a reasonable time the matter. In particular, from this norm, we can deduce the principles of equal treatment, the principles of transparency, because there are some information obligations on the provider, and the principle of proportionality. So I have selected in this for this presentation a few issues rising from this type of internal complaint handling system. In particular, we can find that the complaint is handled entirely by the provider, of course. This is the subject that decides when a dispute can be considered more or less important or complex. The legislator, in this case, does not impose to the provider any disclosure obligation on the criteria that the platform can use, the provider can use to make such evaluation. The provider must inform the user about the functioning, of course, of the system, but despite the importance of this condition to assure a full right of defense, the European legislator only imposes an informational obligation. It's like a general obligation on the general functioning of the system, and we know that when we also when the decision is taken by the with or through an algorithm, makes the algorithm transparent is not so easy. Also in the platform to business regulation affirms the need to achieve a quick and effective bilateral resolution. However, in this case, the platform is legitimizing its role when the business user accepts the terms and conditions, which are unilaterally prepared by the provider itself. So we can say we can say that it is bilateral, but it produces effects between the parties as if its content had been established by mutual agreement. So we can understand the problem in such a provision. Moreover, neither is possible to ensure impartiality, the principle of impartiality, because when the user has activated the internal procedure to complain for an infringement committed by the platform is the same party who will decide the matter. So we can say also the problem with the principles of impartiality. For the mediation, we can say, first of all, that the regulation, the platform to business regulation, highlights the voluntary nature of this mediation, because this type of mediation is quite different from the traditional mediation provided for the consumer. In particular, the requirements for mediators can be that we can find in the regulation is that the mediator has to be impartial and independent. He has to assure the affordability of prices for their services, granting their activity without undue delay, of course, and he has to be reachable physically or telematically, and he has to have the knowledge of the language of the contract enforced between that kind of user and the provider, and a general knowledge about the technical knowledge about how the business-to-business relation works. Even in this case, I have selected two main issues arising from that type of alternative dispute resolution, the mediation in particular. First of all, there is also for the mediation, there is a problem of impartiality, because the choice to identify the mediators is left, of course, to the provider, who could appoint individuals easily controllable by the provider itself. So, but anyway, we can say that the user have enough power to discuss with the platform and to complain, to oppose the mediator that the platform has chosen. So even in this case, there are some problems about the impartiality principles. On the other hand, we can say that the agreement reached out at the end of the mediation, of course, has not the same force as a court order, because it has only a private nature. The platform to business regulation does not provide any sanction, and the Directive 52 of the 2008 on certain aspects of the mediation and in civil and commercial matters, which is quite nominated in the regulation itself, in the platform to business regulation, delegates its task to the member states. So it's clear that different member states can decide for a different solution in this case. So there is a negative effect for the principles of effectiveness, of course. So for the last slide, I would like to highlight some preliminary findings. There are lots of pros for the ODR, such as the deflective effect of litigation before national courts, the rapid, the free, accessible and free of charge low-cost justice for business users, but the markets, the practical markets, have shown that there is often only formal adhesion by providers to the provisions of the regulation platform to business regulation. So I think that there is a need to see how those tools are applied in the real markets to deal with the contractual power of providers to implement a more effective instrument. And so in my opinion, the platform to business regulation is the first important step, but no longer enough to address the abuses, the problem of the power of platforms and the possible abuses of the platform, the providers itself. So this is my extended abstract. So thank you for the attention, and I can wait for your questions. Thank you. I can hear you, I think.
Pardon me. I just mute my microphone in order to don't interrupt you. I don't remember if I mentioned before, but we will have the question time at the end of the presentation of the first three papers. So I kindly ask you to stay here with us in order to collect the question at the end. Okay? Thank you very much. It was very interesting. Next speaker is Niccolò Bottura, which is speaking about a very broad argument and very hot argument, which is artificial intelligence, facial recognition, and privacy risk. We know there is a big debate nowadays about the use and the possibility to use these technologies and for which end is possible to use this technology. So you are very welcome to introduce your extended abstract. Thanks, Niccolò.
Yeah, so good morning to everyone. I am Niccolò Bottura. I am a lawyer and I work in a compliance team of Bonelli Areda law firm dealing mainly with data protection. In my extended abstract, I try to analyze the possible impacts that derives from the use of the biometrics data for facial recognition technologies, giving also some possible remediation in terms of privacy, in terms of data protection to protect rights and freedoms of individuals, and to mitigate risk, for example, profiling risk. So facial recognition is a long-standing challenge in the field of artificial intelligence. This type of technology belongs to the branch of deep learning, and it can be defined as an automated processing of digital images that contains face of individuals. So it involves automatic extraction and digitalization, comparison of faces, spatial and geometric distribution of the facial features to identify an individual and to recognize characteristics of human faces. Individuals are nowadays continuously subjected to facial recognition technology by condescendence or without being aware of it. So using a digital photograph, an artificial intelligence algorithm can extract and create a digital template and compare it with a list of photographs collected from different sources, for example, social media. So this means that these technologies uses biometrics data related to the physical, physiological, behavioral characteristics of an individual, which allow confirm its unique identification. Special categories of data that can reveal different informations, specific information about an individual, for example, ethnic origins or sexual orientation or political group memberships, for example, but also information about health. So the revelation of this data can expose individuals to different forms of discriminations. So it's important to ask ourselves, is the use of this data, the use of biometrics data, can be a danger, can represent a danger for rights and freedoms of individuals. So there have been significant applications of these technologies in all the world over the past 10 years, especially for law enforcement investigations in the US with the development of Clearview AI technologies, or simple to create an identity national system. For example, in European Union, France could be the first country to implement facial recognition systems to create a national identity. Even if the data protection authority in France gives a contrary opinion about this topic, say that the consent will be not free. So the danger is to fall into surveillance systems that create a sort of public control. In our country, the law number 205 of 2021 provides the suspension of the installation of these video surveillance systems with facial recognition technology, as there is a lack of regulations on the subject and several questions about the balance between different interests like privacy and national security, and different principles, in particular the principle of proportionality. It's important to give evidence the fact that in Italy, the control of the legality of this system is still left of the data protection authority. Different order of injunctions during last years were given to different companies like Clearview or Sport Italia, for example, for processing biometrics data in violation of the general data protection regulation. In particular, these data were processing without a legitimate legal basis or in violation of different principles like principle of minimization or principle of proportionality. These measures take over from the guidance expressed by the Council of Europe, where a ban is required for the only purposes of processing data related to skin color or to other important aspects of person. The same regulation prohibits the processing of this type of data, except in some cases. but the rule give also as an important point of view, says that we cannot process this data without proportionately with the aim, with the purposes. So the guidelines on facial recognition of 2021 states that facial recognition cannot be used in uncontrolled environments for the only purpose of gathering data that may lead to identify persons, to identify individuals. So the mere use of these technologies for facilitation purposes, for example, to control exit of students in the school, can create dangers in terms of underestimation of the impacts of this kind of technology on privacy, on our rights, can create risks, for example, geolocation or data profiling. The European Commission has attempted to introduce a moratorium on the use of biometrics data from 3 to 5 years, but this regularity gap contributes to undermine privacy. Privacy intended as defined as the protection of existential choices against public control or social stigmatization. So GDPR introduced lots of principles to protect rights of individuals, in particular transparency, giving information to the users, and also adequacy and proportionality. This principle is important to avoid discrimination and reduce risk of profiling. In particular, profiling is considered one of the most critical and insidious form of automated processing. Can be defined as the automated processing of personal data, which can evaluate and predict different aspects related to persons, in particular health, related to health, work performances or behavior, or different interests of the person. So it still happens that when a company starts profiling process, don't notifying on or obtaining consent from individuals in breach of GDPR. GDPR states that each data subject have the right not to be subject to a decision, in particular, not to be subject to an automated processing, including profiling, which is deemed to have legal effects or significantly similar effects. So each of us can freely decide to give consent to a processing. So if a company obliges someone to give consent, this use of data is improper, is irresponsible, or can be considered also illegal. The consequence are relating to different forms of discriminations in terms of health, financial, for example, or reputational discrimination. So profilings contribute to create ethical issues. So what kind of actions can public and private players can do to protect privacy of individuals and mitigate risks, for example, profiling risk? GDPR states lots of different requirements, and data controller, being guided by principles like transparency or privacy by design and privacy by default, have to prior to the processing, have to make an assessment of the impacts to identify typing of processing that have an high risks for rights and freedom. The use of biometrics data, for example, for systematic monitoring on large scale or systematic monitoring of individuals, is a type of processing to be subjected to a data privacy impact assessment, identified also by the criteria gives by the Working Party 29. So it's important to think about the purposes of the processing, but also determines the risk in terms of probability and severity, and adopt accurate countermeasures, in particular technical and organizational measures like encryption, pseudonymization, or adopting procedures about the use of, for example, iris scans or smart glasses or video surveillance systems that use facial recognition systems. So it's important also to give to the user a clear and accurate privacy notice or information with a legitimate legal basis, ensuring right to object and right to error. So we hope that with the proposal on regulation about artificial intelligence, European legislature introduce a classification of risks before the processing of personal data, and recalled the principle and importance of rights already exposed in GDPR. But I ask myself if these measures are enough to protect privacy. So it will be a great challenge, because data are now objects of desire for controls especially by big tech. So the widespread use of this kind of technologies, especially for mere facilitating purposes, can create an underestimation, first of all, but also a progressive loss of freedom. So it can be a danger, even if GDPR introduce several requirements of penalty or sanction. I think it's important to evaluate case by case, evaluate different interests, being guided by principle of necessity and proportionately, introducing also different forms, different soft law and instruments like code of conduct to protect the identity value that European legislature is affirming during this year, to protect the importance of rights. So thank you for your attention.
Thank you very much, Niccolò, for your research and for your suggestion. As I mentioned, it is a very hot topic, so we really look forward for the discussion in order to better understand your proposal on this. The last speaker of this first half of the morning is Eyüp Kun. Eyüp, are you here? Okay.
Yes.
We can see you.
Yes, I am here. I'm trying to share my screen.
Okay. Eyüp is presenting an extended abstract entitled Challenges of Information Sharing under EU Cybersecurity Law. Are competition law and data protection law hurdles or enablers for information sharing? So thank you very much for staying with us. And as I mentioned, you have 10 to 15 minutes in order to present your research lines. Thanks.
Okay. Can you see my screen?
Yes.
Okay.
You can also send in a full screen. Maybe it's more readable.
Yes.
Okay,
now
perfect.
It's
yes.
Better?
Thanks.
Okay. Good morning, everyone. Today I will discuss the challenges of information sharing under EU cybersecurity law, specifically NIS2 directive and whether competition law and data protection aspects are hurdles or enablers. And I'm a PhD researcher at KU Leuven. So this is the outline of my research. First, I will give brief introduction and the research problem and the research question, then information sharing arrangements under NIS2 directive, then two challenges, data protection and competition law. Then I will give a brief conclusion and recommendations. First of all, what is information sharing within the context of cybersecurity? The companies or entities that are subject, that experience cybersecurity incidents might want to share the cyber threats, vulnerabilities, indicators of compromise, tactics, techniques, procedures, to share this knowledge, to raise the awareness of the cyber threats so that other entities cannot experience the same thing. So the sharing information about cyber threats help prevent, detect, respond, and mitigate incidents and improve cybersecurity, presumably. And for this reason, it is a novelty in NIS2 directive. It was not covered under NIS directive. Now, Article 29 requires member states to regulate information sharing among entities subject to the directive and other relevant entities for the first time at the EU level. So then what is the underlying reason for regulating in the NIS2? It aims to provide legal certainty at the EU level to encourage entities to leverage their knowledge and experience, because there are many researches. Priority NIS directive states that there are some legal challenges in information sharing and some uncertainty. And when it comes to like information sharing or data sharing, companies avoid sharing this kind of information without any legal certainty and needs to try to meet this goal by covering information sharing at the EU level. Why they are problematic from computational perspective? Because these information sharings can be based on information sharing arrangements, and because of the fact that especially under NIS2 there are some specific sectors, and with these specific sectors the information sharing can be concluded among the competitors. And when there is information sharing among competitors, it will be problematic from computational perspective. And from data protection perspective, information sharing might require processing of personal data and sharing of this personal data among those entities, and it causes uncertainty for entities to share this data. And my argument in this paper is that NIS2 directive provides limited legal certainty for entities that want to engage in information sharing, and it is up to member states to provide further legal certainty. Otherwise, this goal of the information sharing under NIS2 will not be met. So, as I said before, like the information sharing arrangements can include all type of information related to cybersecurity, and NIS2 directive promotes formal cybersecurity arrangements. So there is also a possibility of sharing on basis of informal way, but NIS2 adopts formal cybersecurity arrangements for information sharing, and this choice can be justified for trust building. And the most important thing is about the building a trust among these entities, because sometimes they have to share some sensitive information, like even being experienced a cybersecurity incident is a sensitive information for companies because of the reputation reasons, and also legal requirements requires these kind of arrangements like data processing agreements or the the data transfer agreements. And the third issue is to ensure that information sharing is two-way. So not only one party benefit from the information sharing, but there is like a mutual benefits for each parties. And what are the parties that are foreseen under this directive to information sharing? There are two entities, like two class of entities. The first one is entities falling within the scope of NIS2 directive, and we can say like essential and important entities, and it is explicitly regulated under the first articles of NIS2, and there are some annexes in which sectors fall within which type of entities. And the second one is other entities, where relevant can be party to these arrangements. I think this is a novelty during the legislative discussions. In the proposed version, the information sharing arrangements refers to only entities within the scope of the NIS2 directive, but now also other entities. And we can understand from other entities that entities related to cybersecurity service and research, to ensure that they can directly involve in information sharing. I think it is a like appropriate addition to meet the objective of ensuring cybersecurity and raising the knowledge about the cybersecurity in a collective manner. And I think from data protection perspective, it provides a limited certainty. And if there is a limited certainty, it means limited enabler. In this extended abstract, I discussed only the legal basis for the processing of data with other entities, but also transparency obligations, data transfers abroad. All these are relevant, but I limit myself to legal basis. And when you look at the legal scholarship for information sharing in the context of cybersecurity, there are generally like four legal basis for this. And the first one is consent, then the legal obligation, necessity for the performance of a task carried out in the public interest, as well as legitimate interest. For the consent, it is not very appropriate because the data subject can withdraw the consent in any time, and then it might not be possible to share this data. And the legal obligation is not also appropriate legal basis because it is not an obligation under NIS2 directive, and it is neither will be an obligation under member states. So that's why it cannot be considered as that. And for the necessity for the performance of a task carried out in public interest, even information sharing might be considered as a public interest. This is not like the task that is given to these entities. For this reason, this legal basis might not be considered appropriate as well. And the last option is a legitimate interest, and also NIS2 directive clarifies that information sharing is a legitimate interest for the processing of personal data, but it does not provide further clarification about the proportionality step within legitimate interest. It says that, okay, cybersecurity information sharing is a legitimate and necessary, but how we should ensure the balance between these like data subjects' interest and the information sharing is not clear. That's why it might be considered as a limited legal certainty. And when it comes to competition law aspects, some kind of arrangements and agreements are prohibited under 101 of the TFEU if this agreement, among the undertakings and the competitors if they enter into contract that limit the competition, then it's considered problematic from a competition law perspective. But if the benefits of the agreement outweigh the risks of competition, then it might be considered legal under 101(3) of the TFEU. And when it comes to information sharing in the context of TFEU, even regulatory initiatives like in the NIS2 directive may result in information exchange, but it doesn't mean that it is excluded from Article 101. And especially Article 101 applies if an exchange of commercially sensitive information is likely to influence the commercial strategy of competitors. And this is the case if information reduces the uncertainty regarding one or several competitors' future or recent actions in the market. And NIS2 directive acknowledges this issue about the competition law, but it does not. It does just say, these information sharing arrangements might be compatible with Article 101 and in general competition law, but it doesn't provide how, like, the member state should do it or how the companies should do it. And here I would like to have a classification from analytical classification for competition law. The first one is we should analyze this issue whether these entities are providing cybersecurity services or not providing cybersecurity services. If they are not providing cybersecurity services per se, information exchange do not pose a significant risk because the cybersecurity information is not considered commercially sensitive. For example, let's assume that under NIS2 directive, online marketplaces are considered generally as important entities. And if they want to involve in information sharing arrangements among themselves, this is like the cybersecurity information for them, like the threat actors, compromises or IP addresses or the strategies or the techniques that the IT professionals use to combat the cybersecurity incident is not commercially sensitive because it's not part of their core commercial activities. That's why it is not very problematic. But when it comes to entities that are providing cybersecurity services, I argue that there is a further need for further guidance among competitors. And I will discuss these guidance later. And for the data protection, as I said, NIS2 directive provides a limited certainty. And if member states, in the light of ENISA guidance, do not provide these information or more clarity, I think the NIS2 directive will not meet the objective of information sharing. Because, as I said, it is like a voluntary thing. And if there is any uncertainty that may cause for entities, they will not share it to be on the safe side. That's why I would propose member states should define which type of personal data can be shared within these arrangements by creating a non-exclusive or exclusive list to legally share. For example, they would say, like IP addresses in this context can be shared, URL addresses can be shared in this context and with these safeguards. And also, there will be, as far as I understand from the NIS2 directive, there will be some specific platforms that facilitate this information sharing, and these specific platforms should abide by data protection by design requirements in advance to ensure that, and also some specific guidance can be given about the proportionality aspect of the legitimate interest legal basis. And when it comes to competition law aspects, information exchange within cybersecurity service provider may pose a risk. Why? I think I didn't mention it clearly in my previous slide, so let me clarify here. Because cybersecurity is itself also has a market, especially threat intelligence services is fall within this scope of like the information they have. And if they have this information, and if we allow them to share this information, it is true that it will maybe increase the knowledge, but we should have some safeguards to ensure that they will not share commercially sensitive information. For example, some kind of techniques to combat a cybersecurity attack might be considered like a commercial strategy. For this reason, we should ensure that these arrangements, like the information sharing arrangements, consider these computational aspects. And also, member states should ensure that cybersecurity service providers have non-discriminatory access to those arrangements to reduce the risk of foreclosure to other entities. Thank you for listening to me. I look forward to discussion.
Thank you very much, Ayub. It was very interesting. So now we can open the discussion on the first three papers. I apologize, but I have to select the question because we are receiving question by email on the comments. We already received other questions, so we just need to be sure that the question time is into this half an hour. So let's start with the first question to Ludovica. Ludovica, we have a first question, which is kind of a comparative question. The question is, in Brazil, mediation agreements are binding agreements and prima facie are enforceable before a judge. So there is very little incentive to keep the agreed upon obligations unfulfilled. Accepting mediation without the possibility of enforceability seems to be contrary to the principle of good faith. What was the rationale in Europe for establishing the mediation as a non-binding agreement?
Okay. First of all, thank you for the interesting question. Okay, in Europe, actually, the agreement reached out at the end of the mediation is binding for the parties, but it has not the same force as a order of a national court. Because this is because in the digital platform, the relationship between the provider and the business user is has a private nature because it's a contractual relationship, and so all the agreements, all the relationships is the relationship is regulated by contract. So all the agreement at the end of the mediation is has a private nature because of the source of the title of the provider to be such as like a judge, we can say, because he it's the provider that decides at the end of the day the dispute. So I see I can see the point of the question. In my opinion, it's a good point, very interesting. But it's because of that that, in my opinion, the European legislator must consider in a different perspective this problem, the fact that in the platform, in the P2B relationship, there is a lot of abuses of the platforms. So also, in my opinion, this agreement has to be enforceable before a national court, or the European legislator must provide a sanction in case of violation of the agreement, and in the regulation we can't find that. So thank you for the question.
Thank you, Ludovica. I have a question for you, which is from my side. The first question is about some behavior that are also addressed by Regulation 1150. In fact, the Regulation 1150 address also the, how can we say, the deceptive behavior which are used during a commercial relationship with platform to business, with platform to user, sorry. And I was referring to the so-called dark patterns. So we don't have a very blatant violation of something, but are psychological techniques in order to force the user or the customer, in case we are speaking about a platform selling something, to adopt a specific behavior. Do you think that the instruments of mediation are able to address also this very slippery situation where you don't have a clear violation, but you just you must read between the lines in order to find if a behavior is deceptive or not. And do you plan to expand your paper also after the impartiality of the mediator with the competence that a mediator must have?
Thank you for the question. Okay, yes. Okay, of course, in my opinion, the mediation provided by the regulation 1150 is not enough to address such issues, that type of issues, even because DAC partners with, as you said, are not so clear, and so there can be a lot of problems in terms of proof of that type of violation, and also because in the regulation 1150 it said that the platform that the provider that has to nominate at least 2 mediators. So in my opinion, in this case, it's quite quite obvious that the platforms would prefer 2 mediators, more let's say easily controllable by the platform itself. So I think that there are lots of problems with the mediation in platform to business regulation. That is quite different from the mediation provided in case of B2C relationship. And in my paper, of course, my extended abstract deals with the problems with the principles of transparency and the principles of impartiality of the treatment of these issues. So yes, I think that my paper would extend also to that type of issues, even because there is also the problem of profiling. So there are problems. Actually, there are problems that in the regulation 1150 that there are only, let's say, the legislator said that yes, there are some that type of problems with the business, but because indeed we have to remember that the regulation 1150 is a regulation provided for the business to platform relationship, and not for business to B2C, so business to consumer relationship. And in my opinion, the legislator has the opinion that the business is a business, so can manage the problems and abuses with the platform, but actually the real markets show that the reality is quite different. So I think that the legislator has to change the perspective, this point, and then we can address the problem in different ways. Also, the problem of their partners. Thank you.
Okay, thank you very much. Thank you very much, Ludovica. Let's start with a question to Nicolò. Nicolò, we have several questions for you, and they are all related with some risks of embedded, we can say, with the use of AI and facial recognition technology. The first question we received is about the risk of the use of this technology for racial repression and repression of the freedom of citizens. So we're speaking about fundamental rights. So do you think that the use of this system of facial recognition, irrespective of the body or the agency that is using, can pose a risk to the freedom of citizen? Because people knowing themselves to be watched and tracked all time, even at the unconscious level, would end up changing behavior, if only in fear of being misunderstood. So this continuous watching of the citizen can force the citizen in taking what we can say is a social acceptable behavior, which is not how you can maybe express yourself. Let's think about protest against the government, against your employer, and similar. And will there be then a risk of restriction of freedom of expression?
Yes, thank you for this interesting question. So I think that the use of this type of technology influence our behavior, and in terms of creates an impact in our mind. We use continuously forms of this kind of technologies, and we are subjected usually by conditions and also without consent. For example, the use of this technology to control people, for example, during the period of COVID-19 in China, for example, or also in another country, it's has created an impact on this point. So our fundamental rights, in this case, our privacy, our it is compromised because we have an underestimation of the impact on this technology. We use this technology. We use, for example, the iris scans for smartphone to unlock smartphone, or we are continuously detected by the cameras, for example, by law enforcement agency or by also private companies to for public I don't know, for private purposes, and also to verify, for example, aspects of minor crimes. So I think that it's important to make an evaluation in terms of proportionately on the legitimate interests of on the states, because it's very simple to compromise rights of individuals, of humans. So this is the most important focal point on my abstract. So thank you very much for this question.
Thank you, Nicolò. We received also some question from another contributor that asked a very interesting question. Are you confident that it will be possible for AI systems to be evaluated on a case-by-case basis and by any particular player?
I think that I hope that the European legislature, but also all the countries, give us more clear guidelines, more clear guidance about the use of these technologies. A European legislature is trying to introduce an accurate system, for example, in the proposal of regulation artificial intelligence that I've mentioned in my paper, to give us a classification about risk, but the most important point is giving to user clear information. So I think it's difficult maybe making a personalized evaluation, but if we have general guidelines at this point, we can clearly make an application of these guidelines on the reality, on the practice case, or on the reality of things, to make more clearly evaluation about interest, for example, privacy and national security of the states. So it will be a great challenge. There is no possible answer now, but I think that in the future, after having these forms of recommendation, guidelines, different instruments of law, we can have maybe an answer also to avoid these continuously forms of discrimination in different topics like health or reputation. So this is my opinion about this point.
Thanks,
So, thank you very
Niccolò. This brings us to the last question, which we received in the comments. In your opinion, is the current draft of the AI Act properly addressing face recognition technologies? Under which risk category would you qualify face recognition technologies?
I think that the risk is maybe qualified as an high risk for individuals using this form of this technology, but we have to evaluate where it's applicated and for which purposes we can have an application of this kind of technologies. So before in terms of privacy by design, each data controller have to make an assessment and try to predict risks, but also in terms of the principle of proportionality may be useful to balancing interest. In any case, this kind of use of this technology, because of the use of biometrics data, can qualify in terms of high risk in case of systematic monitoring, for example, of individuals in public areas. So there is a different qualifications depending from the purposes. So thank you for this question.
Thank you very much, Niccolò. Let's start with the Ayup. I start from the question that we received in the comments. How do you see the adoption of new acts like the Data Governance Act and in the future also the Data Act with regards to the competition law and cybersecurity challenges?
For Data Governance and EU Data Act, it is not within the expertise of mine, and I know there are some studies about this, but I'm not, to answer this question. Regarding cybersecurity issues, as I mentioned in my presentation, generally it doesn't attract so much attention from legal scholars, especially in the EU. There are some studies also there are some studies and scholars discussed within US context, and especially also Federal Trade Commission issued like a guidance even in 2004 about a question regarding the cybersecurity, but I didn't see any like specific guidance given to information sharing in the EU. Even there is like a draft. There was a draft horizontal like the guidelines on Article 101, but they didn't mention this. I think for especially for cybersecurity service providers, there is no clear guidance to what extent the strategies of cybersecurity or the strategies of mitigating a risk can be considered as a commercially sensitive. I see that also. I asked this question during another conference to a private, like a representative of a private company. Of course, cybersecurity, in this context of cybersecurity, generally we see that there's like a collective good or collective understanding to just mitigate the risk. But also it is like a commercially exploited area. And to what extent they will share, if they share, to what extent it will affect competition is a quite a novel problem, I would say. And still we didn't see any responses. And also from competitional perspective, like at the EU level, we see that I see that they just show the let's respect the competition law without providing further guidance. But in the US, they have more clear-cut solutions. They say, if you do this specific thing, also from data protection perspective, if you just share this kind of information within this frame, then you are exempted from liability to extent that you do it properly and this framework. But here I can see that more less respect competition law when they decide case on case by case basis. But data sharing is already a problem in cybersecurity, and if we do not provide clear-cut solutions or clear-cut way of doing it, like companies will not do it to take a risk for sharing information with others to ensure cybersecurity.
Okay, but if I can jump in the discussion, the sharing of information in order to address the risk of a specific sector is something that we have already seen in other industries. Let's think, for example, about the financial sector, where the sharing of information, for example, against fraud or similar, is something that is made from years. This is part of an approach related with the systematic combating of a risk, meaning that I understand your point of view about competition, but if we are under attack from a cybersecurity perspective, it's not just a problem of the single company, but is a problem of the entire segment of that kind of company. So this is the meaning, in my understanding, of the European legislator, which I repeat is borrowing from other similar legislation. Do you really see this problem? Maybe we can investigate which is the best shape in order to provide meaningful information without discovering too much about the company or about the setting of the company regarding cybersecurity. This, I think, could be another important point of investigation, how to provide meaningful information without discovering too much and without creating the subsequent problem of competition law. Please, I want to know your opinion about this.
Okay, I totally agree with you, and we should likely encourage the collective use of cybersecurity knowledge. But the issue, for example, and I don't say, this is like a very problematic. It is just, I think the competition law is an enabler for this kind of information sharing. But when it comes to, I didn't see this analytical distinction in literature, even in the US literature or in the EU literature, there is no literature as far as I see on this specific competition law aspect. But the problem is, for example, within financial sector, their aim and goal is to mitigate the fraud, and it benefits to everyone, and without like benefiting the only one. But in this threat intelligence sector, let's assume their goal is and their objective is to mitigate risk. But this is commercially exploited by them. That's the difference in this area. Of course, for example, financial sec, also DORA, Digital Operation Resilience Act, ensures also provides some framework cybersecurity information sharing, and it is not problematic for financial sector because it is not their business to sell like the mitigation measures or techniques to combat cybersecurity. But for threat intelligence services, that's how they gain money or how they make profit, to teach others how to mitigate risks or how to combat with cybersecurity. That's why my opinion is just be sure that there is no foreclosure for other companies to be party to these information sharing, for example, to reduce the risk of foreclosure. And maybe like the EU Commission or DG Competition or ENISA should see whether this is a commercially sensitive information for threat intelligence service providers or not. Because, when also the problem is, I see this discussion about cyber nation strategies. Information sharing is good on the one hand, but on the other hand, it might result in like the uniform way of combating cybersecurity attacks. But sometimes it might require some originality. And if everyone agree on something, and if the state of art is lower than the state of art of the hackers or the state-backed entities, then it might cause a problem. In cybersecurity, as for example, we have all like the risk management responsibilities, cybersecurity response incidents, like the incident notification to competent authorities. We can see the same approach, similar approach everywhere, even in the US, like take appropriate and proportionate measures. But the flexibility of the adversarial partners might require more original and novel thinking. And if we always encourage the common way of responding attacks, there would be some problems at the end. Maybe we are not seeing now, but in the future, maybe we would be disappointed by saying that, like increasing knowledge and having a uniform approach is a good thing for cybersecurity. I hope I clarified my position.
Okay, thanks. Just two very short questions. The first is a request of clarification, which is what do you mean in your abstract when you say data protection limited certainty means limited enabler?
Yeah.
Okay, please.
I mean, I argue in my extended abstract data protection, like the NIS2 directive, provides limited certainty for data protection challenges. That's why I consider NIS2 directive as a limited enabler for information sharing. But it doesn't mean that data protection per se can be considered as a limited enabler or hurdle. But how policymakers or how legislators draft the NIS2 directive cause the limited certainty.
Okay, thanks. And the second clarification, is just more an opinion. Do you think that the ENISA guidelines will be sufficient to provide legal certainty and the ultimate scope of information sharing?
I think like the ENISA guidelines generally useful for like competent authorities also to provide guidance, but they should like they see these different approaches and to discuss like for example, for competition law perspective, the issue with like cybersecurity service providers and non-cybersecurity providers. If they aware of this, if they like adopt the guidelines in accordance with these problems, I think it will be good. And generally, I see that like the national authorities, as far as I understand from ENISA website and its guidelines, they're eager to get help from ENISA and in the capacity building for national initiatives. So it will be, I think, enough. It depends on the guidelines, of course.
Of course. Thank you very much. So I think we can move forward and consider close the first part of this morning. So thank you to Ludovica, Nicolo, and Eyup. And let's start immediately, I think, with the second part of this morning, where we have the first paper is presented by Guillem Vargas Pucta and Zilda Mara Consulter, and is a paper entitled Digital Inheritance in Accordance with the Right to Data Protection in the Brazilian Legal System. We all know that Brazil is proposing several acts about data protection. I know there is an act also about artificial intelligence, which is under discussion right now. So we are very interested in listening what is happening, and considering that you are two speakers, please feel free to take 15 minutes between the two of you. Thanks.
I would like to greet Professor Pierluigi Perri, the chairman of the session today, and all the other attendees in this virtual meeting. For me and for Guilherme, it's a privilege to be participating of this event. So good morning, everyone. Well, for me and Mr. Pusta, it's still good night here. So good night and good morning for everyone. In addition to greeting, I would also like to thank to the Information Society Law Center for the opportunity and for the organization of this Congress. After this greeting, so I will start to work. Well, I am professor at State University of Ponta Grossa, which is located in Brazilian Southern, where I teach in the law program. In addition to teaching activities, I also conduct research about law and technology. And there I have the privilege to work with Mr. Guilherme. Well, our research is about digital inheritance. And this because today we all know that not only material goods are accumulated by people during their lives, there are also virtual assets, whatever or not they have financial value or not, we know that. So during our work, several important questions arose. What kind of assets can compose a person's digital inheritance? And what is the fate of assets that have no material value but have personal, family, or social relevance? And if there is a violation of privacy or disclosure of personal data when assigning the destiny of these assets? At the beginning of our studies, the first point we had observed is that in Brazil, there is a gap in law, despite the Constitution establishes both rights, inheritance and the protection of personal data as a fundamental right. This is certainly not sufficient. Well, this is the context in which the research was conducted. So I will now describe a little about the results obtained. In general, the research aims to analyze the Digital Inheritance Institute. It considering the need for expanding digital law related to the fundamental right to data protection. So, the research problem involves the dichotomy at the moment of succession what should prevail? The rights of the heirs or the protection of the personal data of the dead? About this topic, we followed this approach. Considering that digital inheritance is currently a factual reality, not a fictional concept from Huxley's Brave New World, we sought to understand which assets, in addition to material and physical assets, may compose the state to be transferred to the heirs of the dead person. With this delimitation, we subdivide virtual assets in two categories: those of patrimonial digital assets and those with affective profile, also known as existential digital assets. Well, this division is important because, given the legal protection of personal data, only patrimonial digital assets can compose the available patrimony of the dead, or better explaining, compose their digital inheritance, and therefore can be transferred to her heirs. Without this division, the succession of the death can become risky because could occur exposing facts, images, opinions, private elements that only concern to the curious, and their violation can cause various damages to the honor, image, memory, and other inherent human rights, and that should be respected even after their death. I will now describe the current scenario in Brazil regarding this topic. For this, by definition, an asset is anything that has usefulness to the individual, not necessarily economic usefulness, and that can be appropriated by them. Therefore, a digital good is one that exists in the virtual world, not in the physical, the material world. So, among digital assets, as mentioned before, there are two categories. One is that of digital assets, which are those that have economic value. Two, the one that have effective digital assets, which are those that do not have economic value, but contain information, images, data, opinions, behaviors, and may sensitive to the death. We have prepared an illustrative and divided list of some kind of two belonged goods to both categories. Even affected digital assets, despite having no economic value, should be a focus of the law because they can protect the privacy, honor, copyright name, and other rights inherent to the human being. So you can see on the screen most of examples of both categories. In the first column, the patrimonial ones, and the second column, some examples for existential or affective ones. Well, and given this subdivision, only patrimonial assets can constitute the digital inheritance and their transmission to heirs, considering the continuity of its economic activity. It happens directly, just like with material assets that have a physical existence, exactly the same way. They can be subject of a will or, in the absence of a will, passed to heirs through legal means. In Brazil, it can be done judicially or not, depending on various factors that we are not relevant now. Regarding existential or the affective assets, although they are not part of the succession of the curious, the law must focus on avoiding violating the constitutional right personal data protection and persons' rights. As I have already mentioned, both the right to inherit for the heirs of the dead and the protection of his personal data have constitutional protection in Article 5, items 30 for the right to inherit and 79 for personal data. Regarding these two rights, I will first talk about digital inheritance. As there is still a gap in law, as I said, we can see that there are two conceptions that we can find in by bibliographical reference and court decisions. One, a wide conception, which does not make a distinction between the two categories and occurs directly in the succession causa moris. On judicial, there is no judicial manifestation. Is not required. No lawsuits for this, and it only does not happen if the decuius had left a last will manifestation forbidding it. There are several law draftings in progress in the Brazilian legal branch about these issues. There is on the screen. There is just an example. There are also a more restricted conception that respects the difference between patrimonial and effective digital assets. In this case, the transmission to heirs is observed, as I have already mentioned. Patrimonial assets will be transmitted to heirs by testament or by legal means, and effect assets will be transmitted to heirs only if a last will declaration determines it. Otherwise, there will be no access or use of them by anyone else. In the same sense, there are several court decisions, such as one from the Minas Gerais State Court, just as an example on the screen. Well, regarding the personal data and its protection, we have that in 2022 February, the constitutional amendment number 115 had modified the constitution to include a personal data protection in the list of fundamental guarantees and as a fundamental right, and to define the private competency to legislate about it just by national law. So, in the first article, item 79 have this content. The right to protection of personal data is guaranteed under the terms of law, including in digital media. Also, other special laws which could be applied to try to solve eventual problems involving personal data protection in Brazil must be mentioned now. The civil code, that's general, the regulatory mark of internet, and the general data protection law, which are specific laws about digital relations and other points. But no one of them solve the problem of inheritance, the digital inheritance. Well, now let Mr. Pushta the task to finalize this job, explaining what is the state of art of this dichotomy. Please, Mrs. Pushta, the word is yours.
Good morning. First, I want to say thank to the Information Society Law for this opportunity, and it's a honor to me to be here. First, digital inheritance involves a tension between two Brazilian constitutional rights, the right of inheritance and the right of data protection. When it is defended that the transmission of all digital assets with no distinction, the right of inheritance of the heirs is being observed, which is provided for in the 5th article of Brazilian Constitution, in Articles 1784 and following of Civil Code, but does not consider the right of protection of personal data. On the other hand, the position defending this paper, based on the distinction between digital assets in patrimonial and existential categories, guarantees the right of inheritance relate to patrimonial assets and guarantees the right to data protection with no transmission of existential assets. This perspective solves the existing omission, adopts the situation to the constitutional right of data protection, and contributes to the development of digital law that corresponds to the scope of defining responsibilities in virtual relationships. So there is still a scrutinize about this very recent institute, especially in the face of digital assets that constantly change. For this and other reasons, we will continue to study digital inheritance, data protection, and its ramifications. The fact is, death is inexorable, but most problems that can arise with it, especially regarding to digital assets, can and must be avoided, for example, by using the mechanisms mentioned in our paper. So we can see our references that we used in our presentation. And we need to, and now we are available to questions and appointments.
Thanks, Guilherme. We will have the question at the end of the three presentation, like for the session before, but we already have some question for you. So you will have time to speak. Next in line is Claudia Ogresek. Is Claudia here?
Yes, I'm here. Can you hear me?
Yes, you are a bit far from the microphone. Can you?
No, I'm not.
You are not. Okay.
No.
So we can understand you. Not very clear, but we can hear you.
I can
okay.
try
Now
to
it's
change
better.
the microphone if you.
No. Here, so it's perfect.
Okay.
Okay. Thanks. Claudia is presenting a paper entitled Companies' Social Sustainability in Digital Transformation. As you know, the digital transformation is one of the main topic of the Information Society Law Center. So please, Claudia, feel free to present your extended abstract. Thanks.
Let me thanks to the organizer, and for me it's really a privilege to be here and to present my research. I'm a labor lawyer and I'm a fellow of the Information Society Law Center. I've for my slide, can you see my slide? Can you see my slide? Because
not yet.
Not yet. I put my slide in. The slides are on.
Do you miss the command to send the slide, to share the slide?
Yes, I'm not able to share the slide. The slides are on the platform, and but I don't know how to share.
Okay. Well, maybe it's a problem of privilege, but I don't know. Julia, do you know how to give privileges?
I can send the slide if you.
So do you have the button present in at the bottom of the screen?
Yes, but I've already, I see the slide on the platform.
Oh, okay, now we see the
Okay.
slide.
Oh, thank you.
Okay, perfect.
So my paper deals with the critical aspect of social sustainability in companies which are involved in digital transformation. You know, since 2015, the world leaders adopted the United Nations agenda, transforming our world, and they established a set of sustainable development goals. And also the European Union itself consider environmental, social, and governance sustainability as a crucial goals. And also in 2020, the European Commission defined an industrial strategy to support a green and digital economy. So digital transformation in companies represent a chance towards efficiency, innovation, competitiveness, but the transition process requires large investments. So that the European Union, on one hand, allocated large resources in multi-financial programs, and on the other hand, defined what we can described as a sustainable finance. The main important framework about the sustainable finance is the non-financial reporting directive. In this directive, it is requested to report, companies are requested to report on policies to the annulment of the gender gap and its results, and the respect of workers' rights, working condition, diversity, inclusion. But companies evidence in the implementing of the directive critical issues about uncertainty, about the information to be published, and also about the difficulty in choosing the reporting standard of reference. Since there are a large number of standards and framework that exist. That's why European Commission defined 3 pillars for the European Sustainable Finance: to create a science-based classification system of sustainable assets, the so-called taxonomy, and then to introduce a mandatory disclosure regime for companies, and also to set a provision set of tools supporting companies, financial market, and also but the EU taxonomy was adopted with the regulation number 2020-852. And about 1 year ago, a group of experts assisting the European Commission presented a final report on social taxonomy. But unfortunately, for now, the promised tools have not yet been defined. So there's a need to unified and clear classification for the sustainability, for social sustainability. In this speech, my aim is to contribute to on the above issues and examine what aspects are critical to social sustainability for company involved in digital transformation. Since last January, 6,000 large European companies has to disclose their activity to the European taxonomy for sustainable finance, reclassifying their assets, and from the next year, the scope of these requirements would also extend to small enterprise. What about the sustainability KPI? According to I've told you that there is a proliferation of very different approaches. Here you can find the three main important approaches. The one from the Global Reporting Initiative, the Sustainability Accounting Standard Boards, and the World Economic Forum. According to a survey of KPMG Sustainability Reporting, the world most widely used adopted standard was the one of the general gray standard, so general reporting initiative. And in this standard, as you've seen, regarding the definition of social KPIs, it can be argued that the indicator development was concerned with employee health and safety. So health and safety is crucial to define the social sustainability, and also in digital transformation. But what I want you to I want to focus that in digital transformation could imply high risk in personal data processing. And in fact, mapping issues related to social sustainability in digital transformations highlights an increase in the processing of personal data, which is likely to become more complex, potentially pervasive, and harmful to human rights. So, on one hand, digitalization is can help make a workplace healthier and safer. But on the other hand, machine equipment, monitoring, and smart tracking enable companies to collect massive information of employees, big data, profile employees, and artificial intelligence for companies let company to make automatic decisions about tasks, about labor productivity, and also about dismissal. So, in digital enterprises that aim to measuring their social sustainability have to estimate KPIs on health and safety work condition, even regarding mental status and a real and transparent protection of personal data and private information. Not only sexual discrimination, not only gender equality and inclusion, not only work and life balance. But what about a mere legislative compliance here in Europe? Here in Europe, our regulation, the General Data Protection Regulation, does not prohibit or profiling or using the algorithmic decision-making system, but oblige companies as a data controller to a fair data process according to a proportionality and data minimization, prior notice transparency, and a right to access. As we've seen in the guidelines of Data Protection Working Party, the controller must provide meaningful information, and also transparency means that controllers must provide to data subjects relevant information to a fair processing of data. There's an European Union regulatory technique of protection to hold the employer, the data controller, accountable and grant information rights to employee and also to trade union. This is clearly shown in the transposition of the directive on the transparency of work condition in Italy. In our legislative decree number 104 last August, employees have right to be informed on automated decision making or monitoring system, and also this information must be communicated to the union representatives and to the entity bodies. So this kind of approach is the same you can find in the proposal adopted by the Commission for Artificial Intelligence Regulation. Here, for the Artificial Intelligence Regulation, we can find a preventive and proactive approach based on risks and its preventive characterization. What I want you to value is that the recruitment and the selection of individuals and the evaluating candidate interview or making decision on promoting termination contractual employment relationship are considered high risk category of processing data in the proposal of the artificial intelligence regulations. And this in the proposal so take shape also an anthropocentric artificial intelligence models in which various protection techniques are combined, such as the principle of prevention, control, and institutional cooperation. So, and what about another proposal of the Commission on digital platform? On digital platform directive, we can find enhanced information rights over and above those in the GDPR and General Data Protection Regulation. Right to be informed about the access to work, the assignment, the earnings, and the occupational safety, but also about automated monitoring system, and also about decision-making system. And also we can find that representatives may engage in any judicial or administrative procedure to enforce any of the worker rights. At the end, in the European Commission's proposed regulation and directive, monitoring, tracking, and automated decisions are considered high-risk activities, but it will be crucial to define social taxonomy and social standard for companies involved in digital transformation, as digital transformation could lead to high risk in processing of personal data. What about the proposal in this field of the European Commission? We can find a proposal on a corporate sustainability reporting directive and also a proposal on corporate sustainability due diligence directive. In the first one, you can evaluate a change from the because the corporate sustainability reporting directive will start a process of standardization on the sustainability report and in all the fields, not only environmental, but also in the social and governance. And on the other hand, the proposal of the directive on corporate sustainability due diligence focused on the impact for a company on human rights, including workers' rights, health and climate and environment. So company will have to identify risks, and information will be required on company policy, processes, activities, and also outcomes of these measures. So what are my conclusion remarks? Identify social objectives symmetrically to the environmental set and define a social taxonomy will allow to measure and record a qualitative social impact. And on the other hand, guarantee a real mandatory disclosure on personal data, processing profiles, and access to human oversight, and eventual correction of the system will enable decent work, a sustainable protection of the individual through remedies of data protection, non-discrimination, and labor law. So thank you for your attention.
Thank you very much, Claudia. It was very interesting. You know, this emerging topic also for the implementation of single member states about these directives. So we will have time to discuss during the question time. And let's move to the last paper of this morning, which is presented by Malvina Anna Wojcik, and is entitled Assessing the Legality of Using Race as a Variable in Clinical Algorithms, the EU Anti-Discrimination Law Perspective. Please, Malvina, the floor is yours.
Good morning. First of all, thank you very much for having me. It's a great pleasure to be able to share my research with this community. And I'm just uploading the slides. I hope they work. Just a second. Okay, it says there was an issue with my file.
Yeah, but several speakers had some issues, so don't worry, take your time.
Okay, I'll try again.
Maybe it's just a matter of time in order to give
maybe yes
the possibility. Okay, now we see. Yeah, okay, I think it's a matter of time for broadcasting the slide. Yeah.
Okay, great. I'm glad it works. So again, good morning, everybody. My name is Malvina Anna Wojcik, and I'm a PhD candidate in Law, Science and Technology in the University of Bologna and the University of Luxembourg. And the title of my talk today and of my extended abstract is Assessing the Legality of Using Race as a Variable in Clinical Algorithms. And I'll be adopting the EU anti-discrimination law perspective. So the growing availability of digital health data, of course, leads to the development of machine learning algorithms that are increasingly used to support clinical decision-making in diagnosis, prognosis of disease, and also in treatment recommendations. However, as widely discussed, machine learning algorithms, also the ones used in the context of health, can often result in discriminatory treatment, including discriminatory treatment based on race. So, for instance, algorithms that are trained on predominantly on white-skinned patients can not accurately predict, for instance, skin cancer on darker-skinned individuals. However, while the issue of bias in machine learning is widely discussed, it's important to underline that, in fact, the issue of racial discrimination by clinical algorithms predates the popularization of machine learning. And in fact, many traditional knowledge-based algorithms or equations used in medical practice can entrench bias, for instance, through the use of race correction that I will explore in this presentation. The aim of this extended abstract was to tackle the problem from the European perspective, highlighting the unique challenges that we have in Europe, considering the use of race in clinical algorithms, and also assessing the legality of using race mostly at prediction time under the Racial Equality Directive. The very use of the category of race is very controversial in medicine. Because the concept of race, the very concept of race, was in fact created to underline biological differences between people. Racial categorization can be traced back to the 19th century scientific theories of race, and it stems largely from the eugenics movement and the belief in the existence of biological races, some of them superior over the others, that was used to justify colonialism and slavery. And of course, this also had a huge impact on the development of medicine, leading to racialization of certain diseases. For instance, sickle cell anemia was for long considered an exclusively Black disease that had something to do with the structure of the blood of Black people. And that led to the purity of blood concerns and practices that compromised the autonomy and dignity of racial minorities, such as sterilization, marriage control, and birth control. Also, the scientific race theory has led to many pseudo-scientific stereotypes about the Black body, like the fact that the Black body is more hard or durable than the white body, or that Black people have a higher immunity to pain. This, of course, changed after the Second World War and the atrocities of Holocaust that ideologically was largely based on eugenics and scientific race theory. Race stopped to be perceived as a biological concept and started to be perceived as a social construct. However, even today, racial stereotypes about biological differences between races persist in medical practice. And also there is an ongoing discussion about the relevance of the category of race in genetics and genomics, with some researchers still using race as a proxy for genetic ancestry. Moving into the European perspective on race, in the modern socio-political and legal landscape, the category of race and the category of ethnic origin, which are often intertwined and also used interchangeably, remain definitional puzzles. In Europe, we have a strong identification with anti-racism, which of course stems again from the legacy of Holocaust. But this leads to the so-called silence about the race that is essentially based on the presumption that in the modern times, defining race is something unacceptable, and talking about race is something unacceptable because we see it as perpetuating this biological form of racism, essentially. We have no definition of race or ethnic origin, neither in the domestic law in Europe, especially in anti-discrimination law, or on the level of European Union or the Council of Europe. There is a general presumption also in the case law that race, again, is something that is considered biological, whereas ethnic origin has to do more with the cultural things. However, at the same time, there are many inconsistencies, since discrimination based on ethnic origin is still considered discrimination based on race. So we have a lot of definitional conundrums here. This ambivalence towards the concept of race is evidenced in the Racial Equality Directive that prohibits, also in the context of healthcare, discrimination based on race and ethnic origin, both direct and indirect, however, without defining these concepts. And the rationale for this can be found in Recital 6 of the directive, that states that the European Union rejects theories which attempt to determine the existence of separate human races, and the use of the term racial origin in this directive does not imply an acceptance of such theories. So again, a strong rejection of the value of the category of race. However, interestingly, this attitude towards race does not mean that the categories of race and ethnicity are not at all used. For instance, in the context of medical research and practice. So there are studies suggesting that the European Medicines Agency actually increasingly includes information about racial and ethnic differences in drug effects in the summaries of product characterization of pharmaceuticals that are meant to act as guidelines for doctors and healthcare professionals that use these drugs. This is done mostly to approve drugs that are developed outside of Europe. However, interestingly, at the same time, neither EMA nor European Commission has ever issued any guidance on the operationalization of race in medical research and practice, while, for instance, in a comparative perspective, FDA in the US has issued many such guidances. So the first crucial topic that I tackled in my extended essay is the operationalization of race in clinical algorithms. Since correct operationalization of race is very crucial, yet it is often overlooked as a methodology in the design of clinical algorithms. And because we construct race as a social phenomenon, it's not a flat attribute. There are different dimensions of race that require different measurement methods and also are appropriate for capturing different kinds of discriminatory treatment. For instance, self-identified race, self-classified race, observed race, reflected race, or phenotype. So let's say we want to develop an algorithm that detects skin cancer. If we use, and we want it to be racially fair. So if we use racial data that comes from the self-classified race dimension, it might not be accurate because maybe people classify themselves as mixed race, but in fact their skin is what we would consider almost white. So here, for instance, it's more appropriate to use the phenotype data. Whereas, for instance, if we want to tackle discriminatory practices that are perpetuated by doctors, it's better to use the observed race data. So what doctors assume the patient to be. And of course, wrong or inconsistent operationalization of race for a given clinical algorithm can be at best ineffective and at worst harmful to racial and ethnic minorities. And this problem with operationalization of race is particularly difficult to tackle in the European context of silence about race, since the lack of definition of race and ethnic origin in Europe contributes to limited and inadequate collection of disaggregated data on minorities and the general lack of methodology on collecting such data at all, which of course creates obstacles for operationalization of race. And another problem tackled in my extended abstract is the paradox of using race in the design of clinical algorithms, since on one hand, race-blind algorithms, so erasing the category of race, is not a viable option, since even the so-called fairness through unawareness technique does not prevent algorithms from discriminating based on racial proxies. And likewise, replacing race with a neutral category such as socioeconomic background also does not always capture the nature of racial disadvantages. For instance, in case of generational trauma that is linked to being a member of a racial or ethnic minority. However, on the other hand, if we want to include race in the design of clinical algorithms, it's always a value choice, which can lead to either anti-racist or racist outcome. And algorithmic fairness techniques, of course, allow fairness and ethnic origin to be included in a model in a variety of ways, both at the time of training and prediction. However, the latter, so using race in the process of determining the outputs, is particularly controversial because it can go against the principle of formal equality. And I argue that this is the case with algorithms that utilize race correction. So they adjust the outcome of the prediction based on the patient race or ethnicity, of course, with on paper with an aim to offer individualized diagnosis. However, medical professionals often misinterpret a correlation between race and clinical outcomes for biological causation. So there is a lack of contextual understanding of what race means in a given context. So I argue that race correction is only appropriate if deployed, if its deployment alleviates health disparities and it's based on robust evidence that explains the correlation between race, that is of course correctly operationalized, and the given clinical outcome. So lastly, my extended abstract briefly dealt with the legality of using race at the prediction time under the Racial Equality Directive. Of course, as I mentioned, the fairness method that take account of patients' race or ethnicity at the prediction stage are prone to legal challenges. And in my opinion, whether a fairness intervention that considers race at the time of prediction is considered direct discrimination is likely to depend on whether and to what extent race is a directly determinative factor in the decision. And in case of race correction, this is likely the case. So I argue that race correction constitutes a prima facie case of direct discrimination, since one person is treated less favorably than another is, based on a comparable situation, based on the ground of racial and ethnic origin, if this is the sole ground on which the decision is adjusted. And the last question that my extended essay tackles is, can we in fact justify race correction as a positive action? Positive action is allowed under Article 5 of the Race Equality Directive, which states that with a view of ensuring full equality in practice, the principle of equal treatment shall not prevent any member state from maintaining or adopting specific measures to prevent or compensate for disadvantages linked to racial and ethnic origin. So this in theory could apply to race correction. However, in my opinion, there are two important points to be made here. First of all, as we can see, the disadvantage to be compensated has to be linked to racial or ethnic origin. So the race adjustment must be designed to remove a genuine disadvantage that stems from inadequate access to healthcare, for instance, or racial stereotypes. And of course, we need, again, correct operationalization of race to detect such disadvantage. But the key is that we need to detect this concrete disadvantage and prove that it's linked to racial ethnic origin. And the second point, generally, the European Court of Justice considered the positive action as a derogation from the principle of equal treatment. And therefore, race correction should also pass the test of proportionality. So the developer must show that race correction is suitable to address the disadvantage in question, and also that there is no less restrictive alternative available to fulfill the same purpose. And this, of course, will be highly difficult to prove, especially in light of the development of machine learning algorithms that can incorporate race in fairness interventions in a variety of more subtle ways. And also the European Court of Justice seems to apply really strict scrutiny to positive action in cases where it is likely to disadvantage the more privileged groups. And this is in case that concerns employment. So we can imagine that in case of healthcare, the scrutiny could be even higher. And also another point to note is that positive actions should generally be considered temporary. So even if race correction as a positive action is legal at a particular point, its legality can be revised in the future. So these are the main contributions that my abstract made. And thank you very much for your attention. And I'm looking forward to the discussion.
Thanks, Malvina, for this dense presentation. It was very, very interesting. So I think we can move forward and opening the discussion. I will start with Guilherme and Zilda. We received some questions that are related to clarification mainly of some part of your extended abstract. The first is a general question. If you could please define data and the duality of right to data protection under the Brazilian legal system. You are in mute, Zilda. Excuse me.
Okay, now can
okay, yeah, we can hear you.
Okay.
Thanks.
First of all, I would like to congratulate all the presenters this morning. Many interesting researches and relevant subjects. It's a real privilege joining with all of you today. So thanks for the interest questions. Well, we have trying to clarify, we have the digital inheritance and we have the inheritance material with things of life. In the digital part, we believe, and our research shows that it's necessary to divide the digital assets into groups. The first one, with some kind of material reflect. For example, crypto coins. If you have some crypto coins in one bank account, or if you have some kind of prizes at games, you have some patrimonial asset. And the second category, it's the affective assets. This one, there is no reflection, financial reflection, unless directly, because it can have it. Well, for example, a password. Or not. For example, opinion, Twitter opinion, and so. And considering those both categories, we believe that it's necessary divide and follow the regular proceeding like we do to the material things for the patrimonial assets. So they will pass to the heirs of the deceased, will pass by testimony or by legal descendants. It's okay for us, and this is there is no problem for this. The problem is it resides on the second category, the effective ones, because we have the personal data protection in Constitution, and we have the right to the inheritance in the Constitution also. How deal with this? Well, we will have to understand that are two rights, fundamental rights, and we have to ponderate and to make the proportionality and to decide. In these cases, it's important a judicial intervention because to violate the data, the individual data of the deceased, it's important to have an authorization by a judge. Fundamented. It's not owned by curiosity. I want to know the answer, the password. There is no fundament for it. But if a kind, for example, for something, some investigation, we are discussing nowadays, me and Guilherme, about one case that person committed suicide, and there was some weird questions and all the stuff, and so was necessary to break the confidentiality of these accounts to understand what really happens, if it was homicide or a suicide, for example, just for example. So in this case, when it's necessary, a judge will authorize the break of the confidentiality. Otherwise, in another case, when the thing just interests just to deceased, the confidentiality will be kept. I think in small stories, that's it. And so, thank you for the question.
Thank you, Zilda. We have another question. Could you argue the difference between the right to privacy and the view of Anderson Schreiber that you recall in the paper?
Yeah, because the data, personal data, especially sensitive, are belongs to a huge world that is privacy. So data belongs to a small part of a biggest world that's privacy. We believe all who studies the personality rights know the theory of the spheres, the German one. So the biggest sphere is the privacy. The small one inside, it's in Brazil we use to name intimacy. There is no in the American system, for example. But intimacy, it's a small one circle inside the privacy. And inside of the circle, you can find the data, especially personal data, especially the sensitive. There are things that just you knows, just you know. For example, a password. Just for example, it's more than privacy. It's more than intimacy. It's one thing that nobody knows and just belongs to you.
Thanks. And my personal question is, do you had in Brazil any case, judicial case regarding digital inheritance and issue with data protection and the transfer?
Yes, we have, Professor. Especially in my presentation, this small time, in Minas Gerais, one state of Brazil, we had studied, me and Guilherme. And Guilherme, if you want to talk, please. There was a court decision about it, and they use the same idea that we defend here. It must to divide, organize, and decide what we will follow to the heirs by transmission and what must be kept in secret because just interests to the deaf person.
Okay, thanks. This is very interesting because in Europe we had the same issue in regulating these very sensitive things. Thank you very much.
And the law is absolutely silent.
Yes, it's absolutely silent. Yeah, it's true. We also went through two main decisions of the court, but the decisions are not addressing the issue in general, but they are just looking at the specific situation. So you must consider the aim, who is presenting the action, what is the object that they want to access. So I think we need general rules, and after going to the particular cases.
In the law draftings is a completely mess. We have all of kinds, and including violating the data personal data. It's a mess. Yeah.
Can I just do a just commentary? So, like the Professor Zilda said, there isn't a legal provision about digital inheritance. So judges need to work with analogies and principles. And there are two perspectives that judges can work. First, with the direct transmission of all digital assets, with no distinction of patrimonial assets and existential assets, and then another vision with the distinction of patrimonial and existential assets. So with our study, we see that it's so important to consider the existential assets, look into the data protection, look into the intimacy, to the privacy. Man. So we want to help the legislators, to the work of our Congress, to see of the fundamental right of data protection that is very recent. You know? So just in February of 2022, this right was inserted in our constitution. So we thought that it's so important to talk about this in our context.
Thank you very much. We have some questions also for Claudia. Claudia, the first question is a quite long question, but it's very interesting. Does the concept of sustainable development have the potential to constantly include new components? And do you think that the concept of companies' human approach in business in the circumstance of a highly globalized economy and financial flows and multinational companies is really achievable in practice? And what would be conditional sanctions for non-compliance with the adopted standards?
Thank you. This is
it's a very broad question.
Great question. No, as I conclude, the topic, the central topic, is the social taxonomy. Here in Europe, we defined an environmental taxonomy in the regulation in 2020 with the regulation 8052. And by now, a group of experts have drawn down a work about the social taxonomy and because it's it will be crucial to define what we can apply by the criteria do not significant harm criteria, because we have to define the social objective not only relating with the individual employee, but also to the social and local communities. And also I realized that in the social taxonomy proposed by the technical expert group, there's another point. The minimum guarantee is the objective of the governance. So governance is an
we missed you. Your microphone muted. I don't know why.
So it will be crucial to define the social harmful activities under any circumstances, and also the minimum guarantee, because at the moment the governance objectives are more important than the social one. And but at the moment we have no answer. We can also study and evaluate the strategy, the Commission strategy.
Okay. Can you comment on the use of algorithms in the workplace causing possible deviance and misconduct of employees? What do you mean with this expression?
We have different types of algorithms, and we understand that we have a case law in Italy in which the algorithm was considered discriminatory because and also the data controller did not understand completely the logic of the algorithms, used in the for the digital platform worker. This is a great problem because you can have a black box, and you cannot understand completely the logic of the algorithm a lot of times, and so this is very high. This is very high risk for the fundamental rights of the employee to use algorithm in HR management.
Thanks. This brings me to my question, which is the enhanced information rights that you mentioned in your abstract and in your presentation. Do you think that the employer is really able to provide these enhanced information rights? Because several times these added information are just in the hand of the provider of the system, which usually use patent protection or copyright protection in order to not disclose this kind of information. So I wonder if the employer at the end is compressed by a strong position that nowadays the legislator is taking correctly to protect the interest of the employees, and the power of the producer, of the seller of this tool that can use the typical IP protection not to disclose the real logic that is beyond their product. So I really don't trust the total inexplicability of algorithm system. Maybe a full explicability can pose some question about IP protection, and I can understand this, but we must question whether it's possible to have this kind of information, how to provide this information, because information must be meaningful to the employers. It cannot be just, a mathematical expression, say, this is how the algorithms work. And what is your idea about this?
It would be crucial to define the reporting and the mandatory disclosure for companies. Perhaps we can find a solution in the due diligence sustainability directive, and also in the corporate sustainability reporting directive.
Yeah, I'm also wondering, you know, in the Italian decree on transparency, where we have these enhanced information rights, they at some point they invent this quality responsible for quality, who must supervise the functioning of the algorithm. But I wonder, who is this responsible? Which kind of competence must have? How you can exactly understand if is fulfilling its obligation in a right way or not? I mean, we are in this gray area where everything you say and everything you do can be correct, can be wrong, even if you have the best will to move according to the law.
It's a human-centric solution, but I'm not sure that this could be the best solution.
Yeah.
And
I don't know if it is practical as a solution, because, you know, if you put too much human, you miss the benefit of the machine, because human is, of course, a bottleneck comparing to the speed of the machine. So we also need to find a balance between these two elements. Okay, thanks, Claudia. Very, very interesting. Malvina, it's your time. Your paper raised a lot of questions, and I have also some question for you. The first is a long question also for you. The contribution is extremely insightful, especially regarding the multidimensionality of race and as to the problematization of fairness metrics. Indeed, discussion on the legality thereof under the EU legal framework remain quite underdeveloped. The European attitude to conflate race and ethnic origin is considered detrimental by US critical race scholarship. And I think that as academics, we should try to overcome it. I'm curious to hear your view about the possible impacts of EU data protection law on data collection practices as to race. Does it facilitate, jeopardize, or it did not change anything?
Okay, thank you. That's a very interesting question. I think that especially the upcoming data protection framework that is concerning specifically the sharing of data, also concerning health data, so the European health data space proposal, for instance. I think this has a huge potential to actually facilitate the exchange of data, of health data, also for the purpose of research. And of course, this will contribute to the greater availability of data, more diverse data coming from different European states. That will, of course, be very beneficial for the creation of more fair machine learning algorithms, since, of course, one of the major problems that is still widely discussed is we don't have enough data. We don't have enough data on minorities, and this is, of course, true also when it comes to racial and ethnic minorities. However, I think that while we are planning to implement this legislation, it's crucial that we think exactly about operationalization of race. And it's crucial that while we collect this data, we know that we know what the data means, because it's very easy to just collect some data, but without the context, we don't know what dimension of race this data represents. So, in fact, we don't know how can we use it in the development of the algorithm in a safe and responsible way. And I think that this is something that we need to work on, and this is a topic that is neglected, and we need to move from our sort of definition of race as something that is only biological to considering race as something that is a social construct, and this will open the way also for a critical race theory. That there are actually quite a few interesting works considering bringing the critical race theory to Europe, and how it could also help with operationalization of race. And I think that this point is very crucial, because only collecting the data is, of course, a very important issue, but it's only a part of the answer.
Yeah, I totally agree with you. And personally, I'm not a big fan of the European health data space, especially because it's created with this crowdsourcing from medical and non-medical devices, where we know that in medical research, what is important is the quality of data. And of course, you can have quality of data only if you collect from a professional and from a professional devices. So I think it's important to question about where we are going with this exchange of data. Other two questions are about section 1.3 of your abstract, the European paradox of racial labeling of pharmaceuticals. Could you clarify how the EMA operates? Because the fellow is not familiar with that. Do I understand correctly that clinical trials are not required by law to recruit people of different races, but it's just a matter of best practices?
Okay, so this is also a very interesting question. Generally, in Europe, it's true that it's not, in fact, required to include people of different races in clinical trials. This is something that is required by the law and increasingly enforced in the US, for instance. So there is a requirement to prepare kind of a diversity report to ensure that different races, different ethnicities are included, and it's like the trial reports on if there is a significant divergence in performance, we have to report this in during the clinical trial. In Europe, it's not the case. However, we still, that's one thing that I mentioned in the abstract, we still use, EMA still uses the categories of race and ethnic origin when it deals with approving medicines that have been developed in other parts of the world, for instance, mostly in the US. So generally, if we have a medicine that is, for instance, approved in the US, we do not always need to go through the same approval process, clinical trials in Europe as well. So generally, there is a way, and there is a guideline that I am also mentioning in the abstract, that is the ICH5 guideline on the adoption of ethnic and racial data from clinical trials in other countries. And this is a guideline that EMA uses, and it's indeed the only guideline that gives any guidance on the matter. But in this guideline, generally, because it's an effect of a compromise between US, EU, and Japan. So generally, the guideline talks about three main races: the Caucasian, white race, black race, and the Asian race. But again, in a specific context of the EU demographics, this might not be enough. And also there is some evidence that when approving the drugs that were made in the US, EMA also uses the categories that have been adopted in the US, which again might not translate well into the European context. So on one hand, there is a growing perhaps awareness of the issue. On the other hand, there is a persistent lack of guidelines.
Thanks, Malvina. We received also different questions about the proof for developers. For example, what is the burden of proof that developers face in justifying race correction in clinical algorithms? Or how can developers prove that race correction has a prevent or compensate effect on the disadvantages linked to racial or ethnic origin? Did you think about something about this kind of proof for developers?
Okay, so of course the burden of proof is not set in the stone. It depends on many different factors. Of course, as in discrimination law in general, we can rely on statistical evidence. However, as I argued in my extended abstract, this statistical evidence should also be based on correct operationalization of race and the correct operationalization of a given clinical problem, of a disadvantage that we aim to tackle as the developers. Of course, we can argue that the more serious the disadvantage might be. So again, we can show perhaps with statistical evidence how often patients are discriminated. For instance, how often patients are given a lower dose of medicine because they are Black. Because let's say we have thanks to the data obtained, found this strong correlation, and we can reasonably assume that there are a lot of studies about how what is the perception of pain killing medicine for different races, and there is a proof of discrimination. And for instance, the stronger the proof, the more likely race correction would be held proportionate. But as I also mentioned, it's generally a very high burden of proof, since the SCJ tends to treat positive action as an exception from the principle of equal treatment, and therefore, especially when the other privileged group will be significantly disadvantaged in a given case, most likely the measure will not be deemed proportionate, which I think is something that might allow us to move maybe from this very simplistic method of race correction towards more subtle and better developed methods of including race in fairness interventions that can also be enabled by machine learning.
Thanks, Malvina. My personal question is, I found very interesting your research about the absence of legal definition of race and ethnic origin. But I was wondering, for your research and for this specific use of algorithms, maybe we should focus on a clinical or medical definition of race. So race is a concept that for medical research is widely used. So probably besides the idea of socio-political, geographical idea of race that maybe we can transfer into a legal text, we should focus on how they, in the clinical sector, the practitioners define race or look at race in order to understand how to improve the algorithms. Did you search for any clinical or medical definition of race, or the mechanism, how they clusterize according to race?
Yes, so actually there's a lot of research suggesting that most of the times there is no methodology whatsoever, and this is something that is very scary because different dimensions of race are in fact often conflated in medical research. So there are emerging commentaries on tackling this problem. However, it's still far from being solved. And well, for many years, in fact, our medical research has been based on these somewhat shaky categories of race that we don't really know what they mean in this particular context. And of course, there is a huge discussion about the category of race as a biological category. I've mentioned the use in genetics, and there's a huge debate there whether, in fact, race should be used as a proxy for genetic ancestry. And if we want to use it as a proxy for genetic ancestry, we should use data that is basically obtained by genetic clustering. We cannot use data that is obtained through the observed race dimension and say, okay, an observed race, I see that this person is Black, so I assume he comes from, his ancestry is African, because his ancestry might be completely different. So this is something that is widely debated, and I think that if we want to use the dimension of race as genetic ancestry, it should be focused on really the technology of genetic clustering. Yes, so, but generally there isn't a consistent method, unfortunately.
There is just confusion and not definition.
Yes, and in fact, it often happens in medical research that the same very person is identified as different races through self-ascribed race, through observed race, or through phenotype. It's basically one person, but three different races. So,
well, very scary. Okay, thank you very much. We are perfectly in time, so I have just the time to close this morning session and to remind to all of you, even people that are attending through the social media, that we will resume at 2 o'clock in the evening with the data governance chair with Professor Bonavita, where we have 5 papers debating, because one of the contributor just communicate this morning that has a problem with some transportation, so she will not be able to attend. Thank you very much, and see you at 2 o'clock Italian time. And thank you to all the contributors for the paper. Thank you very much.
Thank you very much.
Bye.